Hi, and welcome to another edition of the Trustcast show. And we're happy to have with us today Rich Mackie, and who runs a firm in San Diego and Beach. Both places across the country. We're going to get into that. Welcome to the show, Rich.
Hey, thank you for having me.
So, Rich lost his first jury trial so badly it broke him. Then built a Bicostal law firm branded on his own name and mental health movement for trial lawyers everywhere. Rich, walk me through that first trial and what it left you with.
Sure. I like the beginning. It's interesting to start out swinging. So how to kind of frame that introduction is. So when I did my first jury trial, I lost. I got defense, and I was kind of thrown out on my own to do it alone without any help and whatnot. But we put on a great trial, but I got defensed, and I learned a lot of valuable lessons from that trial. But none more importantly than when I when I was done with the trial, I'm going, why isn't there anywhere to practice this stuff, practice the mechanics of introducing evidence and rotating exhibits and everything. And so I've gone to all the seminars, I read all the books, and so why was it when you stand up in front of people, it's deer in in headlights. So I was looking around, and a lot of the seminar type programs are usually a big exhibition of the wins that someone has, but there isn't really trial mechanics practice involved. So you can't learn how to ride a bike at a seminar. So there wasn't a group for trial attorneys practicing the mechanics. So I created one, and it was called Practice Trial San Diego. The acronym is PTSD. And so, whether you were a new trial attorney or whether you had a bunch of trials but you just wanted to stay sharp, it was an environment where we have a speaker come in and go over an element of jury trial uh, practice, and then you get up and practice. And so you introduce evidence and you cross somebody, do a direct examination. Uh, Up on your feet, learning by doing is the way that it was kind of framed, and it took off. And so that's that's the reason behind such a lovely introduction.
So is that something that's still going on right now?
It is, and so it's based out of San Diego, the practice trial San Diego, obviously, and so it's been taken. It's now working in conjunction with Consumer Attorneys of San Diego, and so now it's called Working Group Wednesday, and so we're kind of um, molding the name around a bit and seeing what happens. But it's every month in San Diego, and it's the last Wednesday of every month, and then we'll be working on a schedule for next year as well, and I'm gonna be spreading the gospel in Virginia Beach as well too.
It seems to me that you'd have a lot of traction on that. I don't know that you could get both new attorneys and and very experienced attorneys to show up as guests. I'm just guessing, but to me, it sounds like a great concept.
No, well, thank you, I appreciate that, and it has really taken off, and so it's when you start something like that, it's difficult because you want people to come and get interested, but um, and so it was tough to start, but because especially with imposter syndrome and things like that, you're going, why would you listen to me? The only trial I had was I lost one, but then I was able to subsequently get back into trials and we got a good one, but um yeah, and so the program has taken off. There's been a lot of interest from newer attorneys and attorneys that just don't get into trial as much as needed to stay fresh. How I'll phrase that is that the defense gets to go in there a lot more often than the plaintiff. The defense attorneys are typically in court a lot more in trials, doing the reps, getting the things in. And so the analogy that I kind of paint is, imagine if a team only practiced plays during the Super Bowl. That's what we do as plaintiffs attorneys a lot of the time because we're not practicing and getting the reps in and getting that in our muscle memory. So the only time that we're practicing in it is during the Super Bowl when we're in our jury trial, and if we haven't been in one in 6 months or a year or longer, it's time goes by. So we're at a tremendous disadvantage when the defense is in there, getting the reps in and always being able to practice and try new things out and things like that. And then the plaintiff is in there not as often. So we need to kind of balance the scales on that. And so get in there and practice and come have fun, and go mess up in the group. Have fun messing up so you don't mess up in front of your jury. And so the concept has been a great one. People have really liked it, and we've gotten a good response each month. And we're just trying to grow it. And one of the big things is we absolutely refuse to take any money, so it is always free. It's for the person. It's genuinely there to help people that were in my position that were looking for help but couldn't get it anywhere. That's what the group is for. Is a safe environment to come learn this stuff. So you don't fall in front of your jury and you can have fun and falling in front of your friends.
So I think of the only one that really comes to mind. I'm sure that there's others. There's Jerry something. I can't remember his name. He's quite famous. He has a trial
Jerry Spence.
class that, yeah, yeah.
Yeah, the or
And it's very expensive, and they only let in a few people. So
yeah.
it's hard to get in, even if you want to spend a bunch of money on it.
Yeah, that's
So
true. And Jerry Spence, it's two programs now. So there's the Jerry Spence method, and there's also the Trial Lawyers College. It used to be one thing, and so I did that too. It's a 3 week intensive course, and I did mine in West Virginia, and so it was 3 weeks of an unexplainable experience of learning all aspects of jury trial mechanics, but also us as humans, what we're doing. But to your point, if you can't get selected or you can't, afford it or can't take the time, this isn't to compete with or mimic that grow, because it was a life changing program and still is. This is to work in conjunction with. So whether whatever school of thought someone's from, or what, if they like a different method or whatever they ascribe to, it's hey, bring it. Whatever you're into, come bring it, but stand up and get in front of people and do it. That's the point. And then it's been tremendously effective, not just for the attendees, but for myself as well.
So the name of your firm, Mackie Injury Lawyers, and so now you're located uh, in San Diego and Virginia Beach, and there's a story uh, there. I don't know if you want to get into that too.
Sure, I can. I'm an open book, and I'll try to be as quick as possible.
Okay, I think that's an interesting story because you were telling me off air before we got started that you decided to move back to Virginia Beach, but you didn't want to leave behind what you had, invested all these years in California law. But for family, you were gonna. But then so go into what happened, how you ended up, and where you are right now as we're talking.
Yes, sir. So to be as quick as possible. So I worked for a firm in San Diego. I bounced from California to New York, where I spent most of my life, and I worked for a firm when I was in college. Well, that firm opened up a firm after I had gotten out of law school in San Diego, and so I went back to the firm that I was originally at. So either way, cutting right to it, I went to law school in San Diego, and I had been practicing in San Diego since 2017. And so I've been, learning all the connections and the knowledge of procedure and all that. So my wife and I started having children, and so it was just me and my wife in San Diego, and so we're kind of looking at the writing on the wall, going, we want children around family and all those kind of things. My mom was starting to have health problems, and so all these different things were connecting, pointing to Virginia Beach, where I had family, where my children could have cousins and things like that. So I had a particular issue because my firm didn't have a location in Virginia. So my options or do I start from scratch and work for another firm in Virginia Beach, and just burn all of my knowledge of California experience and connections and all that? Or do I go out on my own and lean on those connections that I've made and the resources that I know of, and try to take a swing and on my own in California and in Virginia Beach, and try to keep, California alive in that aspect as I grow organically in Virginia Beach. So that was option A, and I'm currently in option A right now. Now, and we just moved to Virginia Beach, and amongst the different decisions that were, or different issues that required a decision, is my mother started not having the greatest of health, and so we thought she was having some light memory problems. Well, after moving across country, we found that it's actually severe dementia, which has been a heartbreaking scenario. And so we've done a move across country. Now I'm living in a home with a 1 year old baby, a 3 year old toddler, a mother with dementia, as I try to start law firms in 2 different states. So I've got a full dance card, and that's where I'm at, and both geographically and firm wise right now.
So let's talk about that or dissect it a little bit. So in Virginia Beach, which I imagine is going to be your primary focus, it, you're starting from scratch there, and starting. Are you going to specialize in personal injury as you did in California, or are you broadening that a little bit?
Good question. And I stay solely in the lane of personal injury. So in California, I've got some referrals and resources there that are coming in, that have I have a California caseload, and then I'm growing organically in Virginia Beach, like you said, from scratch. So I've got a couple of Virginia clients that are in Virginia Beach, um, and I'm going to be staying solely in the injury world for now. That's what I know. That's what I'm an expert in. So I'm going to be branching off that. Um, and then if I were to broaden my practice area, it would be more in the bad faith context. But I'm open to see what happens. But the plan is to stay solely injury, for as long as I can, because that's what I know. That's what I'm an expert in, and that's what I like to do, is help people that have had their lives wrecked by injuries and help them build their lives back together.
So you've recovered settlements from 350,000 to 1.25 million. Walk me through one of those that kind of stands out.
Sure. So one of those was one that stands out just because of the nature of the injury, was a scooter incident that happened in San Diego. I had a plaintiff that was riding one of those electric scooters, and they had to get off the road because cars were coming, and they hit a there was a pole that was removed. It was a light post, and so when it was removed, the base and all the guts and all the hardcore screws sticking up were just left there. And so my plaintiff struck the base of that light post that had been exposed, and had a devastating injury to the face, neck, resulting in a cervical fusion, 2 levels. And so that was a big fight with the city, with a couple other private contractors, and so we fought that one. And there was a lot of there was a lot of issues in the case, just because it's called comparative fault. So how much is the plaintiff at fault for, having been on the sidewalk where they're not supposed to be? And so there's a host of issues, but through those all, we were able to zero in and get a really good recovery. So our plaintiff was able to um, not just recover, but get a nice life restart. They had a pretty rough history, so this was a second chance for them to get their life going. It was a beautiful ending to an awful beginning.
So what's the biggest myth clients have about what their case is worth?
The biggest myth that they think about what their case is worth.
On both sides, that what they think, you know, this huge amount, or they're thinking just a little teeny amount. What
Sure.
maybe there's two myths.
Well, a lot of them would maybe be that if someone was in a clear liability incident, like if they were rear-ended or something like that, that just means it's going to be, a $1 million case. It's difficult because a lot of people will say, "Hey, this is clearly not my fault, and so I got a real good thing here." Well, what the defense has is there's four elements of a negligence claim, which is duty, breach, causation, and damages. So the fault is just the first two. So, yes, you were rear-ended, that covers the first two, but we still have causation of injury and damages. So if the fault is clear, we still have, you know, causation, damages. So that just means the defense just really fights us on causation and damages, meaning that what injuries did the collision cause, and then how much is that worth? So, yes, there was a clear fault collision, but that does not mean the war is over. It means that it's just beginning. Only the defense is going to really battle us on the last two elements rather than who's at fault.
So, what do you see some of the more creative ways that defense um, will use causation, in particular, I guess the determination of how much the injury was caused by the accident. That when you talk about causation, isn't that usually what you're talking? How do you see the defense some creative ways that they use um, to defend against that?
The biggest one is probably property damage. Is so if there isn't a lot of damage to the vehicle, then the the very common avenue for the defense to go is that, hey, there's no property damage or it doesn't look significant, therefore you can't have a significant injury. They really double down on that one, and but they get creative in a lot of different ways, and but you can't win either way. So what I mean is, let's say that there was a collision or somebody fell or whatever the injury was. If they don't go to the doctor immediately, well, then the defense will take that gap in time and they'll argue, hey, look, you couldn't have been injured because you didn't even go to the doctor, right away, or there's a gap in treatment or something like that. But if it was on the other side of the coin, if someone goes to the doctor very fast and then they continue to go, then the defense will flip it and say, look at they're going to the doctor so much, they're obviously trying to inflate their claim to have these bigger bills, and so you can't try to outmaneuver where the defense is going to go a lot of the time beforehand, because no matter what you do, that's what the problem is going to be highlighted. So if you don't go, then you get in trouble for not going, and that's what their strategy will be. If you go too much, or in the defense's eyes, too much, well, then that's what they'll make the case about. So um, you're not going to outmaneuver prior, and so I don't believe in manufacturing anything or trying to frame a case a way to cut off a defense, a creative strategy. Mine is tell the truth. And so if there's an injury and then someone has a story after that, then whatever that story is, if the person is truthful and honest, um, that story will stand up to any kind of creative outmaneuverings. And so when I only represent good people that are telling the truth, and so when you have that, it's kind of whatever they want to come up with on the other side is rather insignificant, because whatever they come up with, there's going to be a reason that explains or puts into context the why.
Hmm. So, so we're talking about, so if somebody goes to the doctor, they don't go to the doctor. I've talked to many different attorneys, and everybody always says, when you're in an accident, if you're injured, you want to get to the doctor as soon as possible. If for some reason you don't, how do you address that at trial, or what would you tell somebody about if you're in an accident, even if just feel sore about going to the doctor, or refusing an ambulance, or
Oh yeah, it happens a lot. And so one of the big things that happens, which is a reason why people don't, is that after a collision or an injury, there then a lot of adrenaline floods the body. So a lot of people don't even realize that they're hurt until a few days later. So if you get involved in a collision, it's not abnormal to have that adrenaline not it tapers down. The way the adrenaline tapers down as it goes down, and then when it's gone, people will only then realize something's wrong. So yes, 100% after any kind of collision or injury, go get checked out because you get one chance to do initial imaging and whatnot. And that's just to protect our health, and there isn't anything more important. But also is that if there is a collision and someone hasn't gone, that doesn't mean that that's the end of the story. That someone wasn't that it was ambulance only from the scene, or else somebody doesn't have a valid injury. It's that when we only realize that we're hurt a few days after the injury, well, that's a valid excuse not to have gone. They didn't know they were hyped up and adrenaline was pumping and they were involved in this traumatic event. There's a lot of gray area in it, and everything's not necessarily black and white. But as a rule of thumb, if there's an injury or if there's a collision, go get checked out.
So the rules for these personal injury lawsuits, vary pretty dramatically by state. So I get in an accident and the other driver has limits on their policy, say like they have $15,000 in coverage, but my injuries are way in excess of that, then what are my options? And how could Rich Mackey help me out with those?
All right, great question. And so that's the one of the biggest, not just frustrations, but one of the times that doing this it just gets really sad because the way that you protect yourself is by having what's called underinsured, uninsured motorist coverage, and that comes from your policy. So, a lot of people will get the minimums just because they don't want they want the cheapest insurance, right? Because we're all struggling and want to keep our bills low, but it's not safe or very smart to be assuming that everybody is running around on adequate coverage, and so there's a lot of people that are running around with no insurance or very minimal insurance. So if a big injury were to happen with only those minimal insurance amounts, well, then that can limit what the recoverability is. And so how we protect ourselves from that is through our own insurance, having the underinsured coverage in case we do get hit by somebody that is inadequately insured. But like you said, it's a very intricate process. So each state is different. There's at fault, and then there's different types for different states. And so when there is an injury or a collision, you want to make sure that all policies that could potentially cover the injury are known about, pursued, so that can maximize the person's ability to pay their bills and recover what is out there.
So this brings up the secondary subject that's kind of related to this, is when you get in an accident, you think, okay, well, I'm a logical person, so I know that the other insurance company is going to try to, outsmart me, or maybe they don't. Some people don't recognize that, but many people do realize the other insurance company that the is going to try to get you to settle if they were at some sort of fault, and then there's some resistance to talking to them, but then your insurance company, you lower your resistance and you're willing to talk to them about every kind of detail. What's the so given the context of what we just talked about, talk about the mistake that you've seen people make in talking to their own insurance company.
That is a great point. And so, what happens there, and it happens all the time, is you're right. We think that the other person's insurance, they're gonna play all these games, and I hope that people look at it that way. But then as you're indicating, the guard goes down when we're talking to our own insurance company, and we think they're on our side, and it couldn't be further from the truth. So, the when an injury happens, both insurance companies are activated, and now their job is to pay out as little as possible, no matter what. So, um, from the other side's insurance, the person that causes the collision, the other driver, if we're on guard, we need to take that same on guard to our own insurance carrier. And one way that that manifests itself is in the recorded statement. So after an injury or a collision, our own insurance company will be very quick to want to get us recorded, um, about how the incident happened and what kind of pain they're feeling. And they do that for a number of reasons, but some are pretty not sadistic, but they are not in good faith. What happens is they'll say, "All right, give us your version of the events," and you'll go through what happened with the collision, and they'll say, "All right, my neck and my back hurt," and then you'll be under oath, and so they'll use that recording later. And how that manifests itself is, let's say that a couple weeks after the collision, you're going, "You know what? My knee never felt the same after this incident. It's still kind of clicking. I don't know what's going on." And you go and get it checked out, and it turns out you have a hairline fracture or something like that. Well, later, when you're submitting your claim to the insurance company, the insurance carrier will say, "Well, what are you talking about with this knee pain? We recorded you and we have you under oath right after the incident happened. You said that it was only your neck and back. You must have fallen down the stairs and now you're trying to commit insurance fraud by saying that you have some knee injury when that didn't happen in the collision at all." And then the person's going, "Well, oh my gosh." And so um it can get out of control pretty fast. And so as you're alluding to, we want to be on guard when we're talking to our insurance company, whether it's the other side's, whether it's our own. And the game changes when you have an attorney. And so a lot of the games can stop when an attorney is involved. And so that's usually the route that I would advise.
So let's say I get in this accident and their insurance company calls me up and wants to, and I'm maybe feel like a minor injury to start. Their insurance calls me up and says, okay, we'll give you whatever, $2,000 or, some nominal fund, whatever they try to give to you. And you say, no, I need to, I don't know yet. And then your insurance company calls you up and they are just, it seems like a innocuous kind of call, and they're asking you questions about what happened. What would your advice be to on how you address that as a consumer? So let's say it's just me and I just got in this accident. I think, well, my neck is bothering me. The other guy's insurance company called me, and I really don't want to, I'm not going to do anything with them, but let me call my own insurance. I'm going to call them and ask them, hey, what should I do here? My neck is bothering me, but I'm not really sure. And a- uh, sh- should I do that? Or what would be my alternative? And if I get an attorney, how does that work in the conversations between the two insurance companies?
Sure. So I'd always say, if it was my mom or my sister, I'd say get an attorney. There's a lot of different things that are at play when dealing with insurance companies and a legal claim, and a lot of these things going on in the background that the attorney will be aware of that the person doesn't know, can be big things like the recorded statement, like we were talking about before, or my rule of thumb and kind of a golden rule is that you don't ever try to close a claim while someone is still actively treating. So if someone is going, my neck hurts and I don't know why, the last thing on their mind should be closing the claim out with $2,000. The adjuster or the insurance company on either side, they don't know what injury you have. They don't know how long it's going to take and what kind of treatment is it's going to take for the person to get back to normal. So when the insurance company starts offering amounts and we don't even know what the injuries are yet, then it's way too premature. So don't take any money because the insurance company is trying to get the claim closed before the person can get treated, find out they have a bigger injury, and then the defense or the insurance company is on the hook for more. And so it's not in good faith that they're offering amounts right after a collision and trying to get it closed before it grows into something that they'll be on the hook for. So an attorney can navigate the both insurance companies for the person, so the person can just worry about treating and getting better, but don't consider closing a claim when someone is still treating or if they're still going through symptoms. Um, the insurance company doesn't have a crystal ball. They don't know how long an injury will take to treat. And so if in the beginning, if they're saying, yeah, we'll give you, $1,000 because you're going to need 6 chiropractic sessions, it's how could they possibly know what injury someone has and what treatment it's going to take and how long down to the week it's going to take for something to resolve? They don't. And so they're throwing numbers at you to take advantage of you. And don't take it, because what can happen is let's say, you take that 2,000 bucks and then you go to the doctor and then you have all these, it turns out you have a big issue and it requires more treatment. It turns out there's an underlying severe injury or something like that. And now you have thousands in medical bills, and then you go to the insurance company and say, "Hey, look, it turns out I had a big injury," and they you try to submit what you have. They say, "Hey, sorry, you took 2,000 bucks 2 days after this happened. You don't have a claim anymore. So good luck." And then the person is left with all these bills and an awful situation, and it's difficult to unravel. Because the claim has been closed because the insurance companies were preying on someone before they even knew what injury they had or how long and what kind of treatment it would take. Um, you shouldn't be.
Can insurance companies ever get so in can you ever use that against someone? So you take someone who is naive, and like many people are, I mean, not even dumb, just naive about the process,
Yeah,
and the insurance company takes advantage of that person in a way, getting them, almost coercing them to sign away their rights prematurely. Can that ever be framed as bad faith?
sometimes a lot of it depends on the context, and it gets into a whole different area of law. But yes, when the naive are preyed upon, it does open different doors. But it's and like you said, it's not stupidity or something like that. It's I'm naive when I go to the mechanic. I'm naive when I need a plumber. I'm naive when um if I need an electrician and I don't know what to do. And so there are people in superior areas of power of knowledge, and so it doesn't mean that we're stupid if we don't know the in and outs of every situation we get in life. And so this is just one of those situations where another specialist is required. And so dealing with the insurance, dealing with both the other parties and our own, and knowing what is going on and what each is trying to achieve, that's it's very important, because both sides do prey on the lack of knowledge. Just like, if you go to the mechanic, then someone's always worried that, oh, they're gonna. If my wife is always concerned that if she goes to the mechanic on her own, then they're going to prey on her because she doesn't know the language of which they're speaking and whatnot. And so it's a very valid concern, and I would really stress that on people, that just because you don't know what's going on doesn't mean that you're stupid or anything like that. It's this is a specialized field where there is a lot going on. And so having a specialist navigate that is not abnormal, and that's why it's recommended so much, is because there's a lot going on that we just don't know unless we've done 100 of these, 1,000 of these. And so um, that's why it's primary to get someone that knows what's going on and get them uh, to be navigating and running point on the claim, so the person can just focus on treating and getting better, and the attorney takes care of everything else.
That's an excellent comparison. The mechanic, and I think of car dealers too. If you're buying a car, it's like, oh, what they know, what you don't know. Uh, there's so many. That's a really good comparison. So when I, I Um, I talked to a lot of attorneys, just because of the show, but, one thing that I have heard come up time and again, there's some major, um, litigators or major companies, and I don't wanna really name them, well, because I don't wanna get sued, um, but there's some major companies that will come into an area and they don't even really have lawyers in that area. They'll put up an office or maybe use co-office and they have a big name and they advertise, like crazy. And they get all these people in, they talk to people on the phone, and really they're just farming everything out. How do you know um, when so that you don't kind of fall prey to that because they're I think of the word as settlement meals. They're not going to really represent you, or they're not willing to take it all the way to trial. They're really just there. They're going to settle them, and they want to settle them as quickly as possible. How do you know you're not getting a settlement meal?
Yeah, that's a good question, and you're right. There's a lot of, there's firms out there that they just have a tremendous marketing presence and ads and things like that. Um, if you're getting bombarded like that, it's a good time to have the feelers up, going, all right, what's going on here? But a way that you can navigate that is, hey, when I sign up, am I actually going to be able to talk to my attorney, or am I going to be passed off onto just the legal assistant or paralegal or things of that, or my case manager? Do I actually get to speak with my attorney? And if you are, then it's a good time to be able to ask background questions like, do you go to trial? How often? Um, and there's questions that you can ask that of the type of service that you want beforehand. So, am I going to get to talk to my attorney? Am I going to be dealing directly with them? Yes. Okay, great. And then knowing, did you guys go to trial, or is this just going to be a settle quick kind of scenario? Um, and a big one is being able to talk with your attorney. So, if you're not able to speak with your attorney when you want to speak with them, um, that's where you're getting kind of if it starts to feel like you're a number, that's a good time to be concerned. And so when you deal with a firm like mine, or one that isn't, bombarding with marketing and things like that, you get a lot more of a white glove service because I keep an intentionally small caseload. I don't bring in a lot of cases because these cases, just like we were talking about before, are specialized. They require a lot of attention. And so, in order to give the client and the case the attention that it deserves, you can't be overflowing with some massive caseload, because you just can't, the fires will always take up the time. And so, at a firm like mine, you get to deal with me directly, and we keep a small caseload so we can give each client and each case the attention that it deserves. And so, if you're not getting that, that's when the flag should go up.
So, if all this is making sense for somebody, then how do they get in touch with you, either in the Virginia Beach area or in San Diego?
There you go. I've made it as easy and as catchy as possible. So the phrase is, injured, get rich, Rich Mackie. And how you get rich is 838. Well, you call 838 and then get rich. And so that's 838-438-7424. But it's very easy to remember. It's just 838, get rich. And then Mac.
So, and that means not necessarily get rich, like as in wealthy, but you get rich because rich is going to protect your interest.
You
But I
actually
do like the catchy way that that works. That's very good. Okay, Rich. Well, thanks for coming on the show. I really appreciate it.
Thank you. I really appreciate it too. It was great to meet you, and thank you for having me on.